Yeah, the elector needs to come back just a fraction. Good. That's good. Thank you. All right, ladies and gentlemen, again, we are ready to proceed in cause number 22-39733, the state of Texas versus Ankur Patel. And his attorney and the state's attorneys are present. When we broke for lunch, I think the parties were considering whether they were going to present any further evidence or not. State of Texas.
Nothing further from state.
And defense.
Nothing further, yeah.
So both parties have rested. And ladies and gentlemen, this case is now about to go into your hands for disposition. At this time, I'm going to read to you the charge of the court, which contains the law applicable to this case. In continuing to discharge your responsibilities as jurors, you must continue to observe all the instructions previously given to you. These instructions are given to you because your conduct is subject to review, the same as that of the witnesses, parties, attorneys, and myself. Please listen carefully, as I know you will, as I read this charge to you. This charge will be left with you to refer to as necessary during your deliberations. Members of the jury, the defendant stands charged by indictment with the felony offense of driving while intoxicated, alleged to have been committed in Jefferson County, Texas, on or about February 14th, 2022. The defendant has entered a plea of not guilty to this indictment. Our law requires that I submit the following charge to you in this case. This charge contains all of the law necessary to enable you to reach a verdict. If any evidence was presented to raise an issue, the law on that issue must be provided. Definitions. So that you can better understand some of the words and terms used in the charge, the law provides the following definitions. Driving while intoxicated. A person commits an offense if the person is intoxicated while driving or operating a motor vehicle in a public place. The offense is a felony if the person has been convicted twice before of this same offense. Intoxication. Intoxication means A, not having the normal use of mental or physical faculties by reason of the introduction of alcohol, a controlled substance, a drug, a dangerous drug, a combination of two or more of these substances, or any other substance into the body, or B, having an alcohol concentration of 0.08 or more. The term alcohol concentration means the number of grams of alcohol per A, 210 liters of breath, B, 100 milliliters of blood, or C, 67 milliliters of urine. Motor vehicle. Motor vehicle means a device in, on, or by which a person or property is or may be transported or drawn on a highway, except a device used exclusively on stationary rails or tracks. Public place. Public places means any place to which the public or a substantial group of the public has access and includes, but is not limited to, streets, highways, and the common areas of schools, hospitals, apartment houses, office building, transport facilities, and shops. Prior convictions of DWIs. Evidence has been admitted in this case concerning the defendants having been at least 2 times previously convicted of being intoxicated while driving or operating a motor vehicle in a public place. If he was, you are instructed that such evidence cannot be considered by you as to any matter proving or tending to prove that the defendant was intoxicated while driving or operating a motor vehicle in a public place on the date the defendant allegedly committed driving while intoxicated, on or about February 14th, 2022, as indicted in this case. Evidence of prior DWI convictions can be considered by the jury for the issue of whether the defendant was indeed convicted of 2 or more DWIs, which constitutes a third-degree felony as alleged in the indictment. Let me just take a moment so that you're not confused here. The instruction states what the prior alleged convictions of DWIs can be used for, and it takes 2 or more to constitute a felony offense. And that's really the issue you're going to be determining, whether those prior convictions were valid, and goes toward the 2 or more convictions, which makes any DWI conviction subsequent to that a felony offense, subject to a felony offense. What we always caution jurors about is when you hear evidence that a defendant may have been convicted of other offenses than what is accused in the indictment, be very careful. You don't want to penalize or punish someone for being a criminal in general. That would be inappropriate, because each separate act charged has its own culpability and responsibility for a fact finder, a court, or a jury to decide. So that's what this cautions you. Because he may have been convicted of other crimes, that doesn't make him just a bad person in general, so thus he must be guilty. Again, it goes toward the elements of this particular crime that you are going to be determining, and that is the accusation that he committed an offense of operating a motor vehicle in a public place as indicted in the indictment, and it is alleged he has 2 or more prior convictions. And it was for that limited purpose that you make a determination. Now, other bad acts or criminal acts can be considered by a jury during a punishment phase. And that's part of the bifurcated system we have. We make one phase, the first half of the contest is guilt or innocence. Then the second half is for punishment. And this is the first half. So focus on the elements of the crime as the evidence was presented. Charge. Now, if you believe from the evidence beyond a reasonable doubt that in Jefferson County, Texas, on or about February 14th, 2022, the defendant, Ankur P. Patel, also known as Ankur Patel, did then and there operate a motor vehicle in a public place while the defendant was intoxicated, and it is further presented that prior to the commission of the charged offense, which is referred to as the primary offense, that on November 27th, 2017, in cause number 17 CCR 360 in the County Court of Chambers County, Texas, the defendant was convicted of an offense relating to the operating of a motor vehicle while intoxicated. And on July 30th, 2020, in cause number 324111, in the County Court at Law number 3 of Jefferson County, Texas, the defendant was convicted of an offense relating to the operating of a motor vehicle while intoxicated. Then, all of that being stated in that paragraph, then if all true beyond a reasonable doubt, you shall find the defendant guilty of the offense of felony driving while intoxicated. Unless you so find, or if you have a reasonable doubt thereof, you shall find the defendant not guilty. General instructions. All persons are presumed to be innocent, and no person may be convicted of an offense unless each element of the offense is proved beyond a reasonable doubt. The fact that a person has been arrested, confined, or otherwise confined, or indicted for, or otherwise charged with the offense gives rise to no inference of guilt at his trial. The law does not require a defendant to prove his innocence or produce any evidence at all. The presumption of innocence alone is sufficient to acquit the defendant, unless the jurors are satisfied beyond a reasonable doubt of the defendant's guilt, after careful and impartial consideration of all the evidence in the case. The prosecution has the burden of proving the defendant guilty, and it must do so by proving each and every element of the offense charged beyond a reasonable doubt. And if it fails to do so, you must acquit the defendant. It is not required that the prosecution prove guilt beyond all possible doubt. It is required that the prosecution's proof excludes all reasonable doubt concerning the defendant's guilt. You are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. However, you must be bound by and strictly follow the law contained in this charge. Your failure to follow the law could result in a mistrial being declared, and your deliberate violation of this charge could subject you to being held in contempt of court. You have a right to consider all of the facts that are shown by the evidence and to draw natural and reasonable inferences of such facts. You alone have the authority and duty to determine what the facts are in this case. In evaluating the evidence, you must totally disregard what you believe is my opinion about any factual matter. You must not consider facts that have not been introduced into evidence or legal principles not contained in this charge. And it is improper for any juror to discuss or consider anything which they know or have learned outside of the testimony presented to you and the law that's contained in this charge. If a juror should discover that they have any outside information, they must not mention this information to any other juror, nor consider it themselves in arriving at a verdict. Questions and comments of the attorneys do not constitute testimony and must not be considered as evidence. And you must also disregard any statement of the attorneys that is inconsistent with the law contained in this charge. You cannot question the bailiff concerning the testimony or the law, nor should you discuss the case in his presence. If any question about the law develops during your deliberation, it must be reduced to writing and signed by your foreperson and then given to the bailiff. The question will then be answered by the court as soon as possible to the extent allowed by the law. Any physical exhibits, and exhibits were admitted here, any physical exhibits admitted into evidence will be furnished to you by the bailiff upon your request. After the attorneys present their arguments to you, you will retire, select a foreperson, and then consider your verdict. The arguments are not evidence, and you should give the arguments only the consideration you feel they deserve during your evaluation of the evidence. It is the duty of your foreperson to make certain that your deliberations are conducted in accordance with this charge. After you have reached a unanimous decision, your foreperson should sign the appropriate verdict attached to the charge. In returning your verdict, it is your responsibility to make certain that justice is done in this case in accordance with the law and the evidence. Okay, there are two verdict forms. One, we, the jury, find the defendant guilty of the offense of felony driving while intoxicated as charged in the indictment. Place for the foreperson to sign. And the other option, we, the jury, find the defendant not guilty of the offense of felony driving while intoxicated as charged in the indictment, with a place for the foreperson to sign. Only one jury verdict form can be signed. Under the rules, the state of Texas may open and close final arguments. What says the state?
Your Honor, the state would waive its right to open and reserve its right to close.
All right, Mr. Macon, when you are ready on behalf of the defense.
Prosecutors, Judge, Mr. Patel, ladies and gentlemen of the jury, thank you so much for being here and listening. That out of the way, now comes your important job. You've heard all the evidence. Is Mr. Patel guilty of driving while intoxicated? Has that been proven to you beyond a reasonable doubt? How many here, you ask yourself, have I ever made a mistake while driving? Was I intoxicated or just confused? 240, 410, 435. Did the alcohol cleaning the arm have an effect or not? What's been proven to you beyond a reasonable doubt? You're the jury. You decide. Here on the charge, it says, did Ankur Patel did then and there operate a motor vehicle in a public place while the defendant was intoxicated? The case is about it. More importantly, on the next page, in paragraph 2 of the general instructions, you are the exclusive judges of the facts proven, the believability of the witnesses, and the weight to be given their testimony. You decide. You're little like mini judges. The first thing I suggest when you go back is you read or have someone read out the charges. So really it comes down abnormal versus normal. We're lucky here we have a wonderful video that shows Mr. Patel being normal, walking, standing. Oh, we don't have any audio. Well, you just have to take the officer's word that his speech was slurred. Mr. Patel took the stand, and I think it was real obvious that he has an accent. And he told you, yeah, I stopped on the highway. I was looking for a bottle of water and no traffic was coming. It appeared to be safe. But was he driving while intoxicated before he stopped? Have they proven that beyond a reasonable doubt? Does the video show you that? People say, well, how can you stand up and talk to a jury right after the judge tells you nothing I say is testimony and you only have to give it whatever thought you think it's worth? And I hope you think it's worth something, but I can't reach out into each one of your minds, but what I always say is that you're sitting as a judge here of Mr. Patel, but imagine if someone was judging you on these facts. I look forward to your verdict. Thank you very much for your attention. Anything else?
State of Texas.
Again, ladies and gentlemen, I want to thank you all for your time. Hadn't been stretched out too far for you, but hopefully you've all seen by now. I think it's a pretty simple case. I think the elements that the state has to prove, again, that's the defendant, Ankur Patel, on or about February 14th, 2022, in Jefferson County, Texas, that he operated a motor vehicle. So let's look at that first. I don't think any of you have any question as to whether it was in Jefferson County, whether it was on that date. I think we can all agree on that, and that the defendant was the one, in fact, there. Whether he was operating a motor vehicle. Well, on the video, you can actually see him finish driving right at the end. He's kind of going into that lane. Also, the officer testified he saw him. The defendant admitted he was driving. So I don't think you're going to have a problem with that one. Whether it was in a public place, we know it was right there at the Highway 69 next to the Holiday Inn on the feeder road right there. It's in a public place while he was intoxicated. That's what we're going to get to. And here in the charge, the definition of intoxication. It means not having the normal use of mental or physical faculties by reason of the introduction of alcohol, a controlled substance, a drug, a dangerous drug, or a combination of two or more of those substances, or any other substance into the body. So either the loss, use of the normal physical faculties or mental faculties, right? So either one of those can get you there. Or having a blood alcohol concentration of 0.08 or more. So let's talk about the first one, not having the normal use of mental faculties. Well, he stops there in the middle of the road. No Stephen reading. He comes up, he says, first, he said, I don't know if he's saying he was sick or what it was. Then he came up with, I was looking for a bottle of water. But he really doesn't tell the officer at all there. He just says, I'm going to the next exit. And you can tell it's not your normal mental faculties, right? When you're responding with the officer saying, what's going on? And he's over there. You heard the officer testify. He's trying to see, is there a medical situation? Why is this guy pull over, stop in the middle of the road, jumping out? You know, you're thinking maybe something's going on. No, he's sitting there saying, the next exit. He also can't get his ID out of his wallet, right? Is that your normal mental faculties, right? We all know that if you drink alcohol before, consumed alcohol, you know your mental faculties can be off some. And depending on how much you consume, it goes more and more. Then, when the officers continue to talk to him, and you can listen to the video, he is slurring his speech on there. And there is audio. It's on the body cam. Now, it's not on the patrol car. I showed you that just to show you the initial, what he was coming up and what he was viewing from the patrol car, right? But you can hear the entire interaction there on the body cam. You can hear everything that's being said. You can also hear him say he doesn't remember, but you can recall from the video and you can watch it. Also, your normal mental faculties, are we going to tell the officer we love him and help us out, right? That's not normally what I'm going to tell an officer if I'm being investigated for driving while intoxicated, right? It is probably what you've heard your friends say sometime if you were young or whatever. Hey, I love you, bro. You've been drinking way too much. That's what you do hear people say this. But it's not normal for that situation, right? Then also, let's talk about the not having the normal use of physical faculties. Again, turning his head during the HTN. We can all do this. We can look this way. We can look that way or something. But we don't have to turn our heads. And if someone instructs us not to, and we have our normal mental faculties, we're going to be able to follow it with our eyes. However, if we've been drinking quite a bit, kind of hard to follow instructions, right? He moves it several times, and you can watch it on the body cam where he's turning his head instead of just following it with his eyes. The officer also said he observed nystagmus. We also, on the walk and turn, you'll recall that he's stumbling around, he's missing. I mean, it's not even close on some of them. He says it's the shoes. I don't think the shoes caused him to veer off this way. And the officer, you saw him, he even gave him a chance. He kind of said, oh, let's get out of the rocks right here and let's go over here to make sure that there's a flat spot there, that it's not anything giving him any trouble. He brings him over there and lets him try it. And even you can see him, watch the video. He puts his hand on his shoulder to kind of steady him. Give him as much of a chance as he can to pass these tests and to do okay at them. And he wasn't out to get him. You heard him on the video. You heard him. He said some words that I wouldn't recommend him say, but he wasn't looking to take anybody to jail. He was like, might make him pull in there and have somebody come pick him up. But then when they realized he's had priors and also the level of intoxication that he had, he's like, I don't have a choice. So he went through with it and he had to. And so to say he was being harsh on him, I think you saw the video. I think most of you would agree that was anything but being harsh with him. I think he was giving him every chance he possibly could to try and get himself out of the situation. And he had consumed too much alcohol. The defendant admitted to consuming 3 vodka and cranberry. And we know, police officer told us that, you always hear him say 2 drinks or 3 drinks. It was probably more than that, right? We know the truth. Once he drank too much, he went to Super Bowl party, said he was coming home from it. And you could tell by the video and everything on it that he was, clearly intoxicated. Also, remember the one leg stand. I repeatedly had to keep putting his leg down. And granted, I can say everybody can say, well, that'd be kind of hard to stand on one leg. Okay, if they're just putting their leg down and doing it and they're having a tough time, but falling completely backwards and then stumbling around when you're just being asked to lift your leg like that, and he asked him, do you have any medical conditions? Is there anything that's preventing you from doing it? No, he didn't. And he doesn't have any medical condition. There was nothing testified to that. There was nothing to keep him from being able to lift his leg and cause him to fall on his behind. But what would cause you to do those things? To fall on your behind, to tell the officer you love him and just help me out and do it because you consume way too much alcohol. And then, lastly, we have the other one, having a alcohol concentration of 0.08 or more. You heard Miss Altamirano that it was 0.213, right at 4:35 a.m. when the blood was drawn. And the defendant admitted to 20 minutes prior to being pulled over to consuming alcohol, right? The last drink that he had. And so at 15 minutes later, she testified that that would be, you're going to be at your peak, 80% of your peak level. So 15 minutes later at 2:35, before he's even stopped, he's at 80% of his peak level right there. And he even gets a full 2 hours from that point before the blood's even drawn. And he's still at 0.213 at that point. That's nearly 3 times the legal limit. I don't think this is a very difficult case. I'm sorry. I feel like I guess I should say more, but I just think the video, everything that you saw on it, the test, it all points to one thing. He drank too much. Doesn't mean he's a terrible guy, but you got to follow the law. And we know he was on probation at the time, knew he wasn't even supposed to be consuming alcohol. And yet he did. And he knew that. So I hope that you won't take too long. Go back there, though, review what you have to, that you'll come back with a guilty verdict. Thank you.
All right, ladies and gentlemen, at this time, I am tendering the jury charge for your review during your deliberations to the bailiff. I'm going to ask you to please step down from the jury box, follow the bailiff into the jury deliberation room. We will wait with all. And by law, only 12, no more than 12 people are allowed in the jury room to deliberate. So the alternates, I'm going to ask you to hold vigil outside. We've had to replace jurors in the past, even during deliberations. So we're going to ask you to hang in there until the end. So thank you, and relax and stretch your legs, and we'll keep you updated. Thank you.